everyone. We are here for the third episode of our construction law seminar series on YouTube, on Twitter. Please follow us. We have here tonight Matthew Davies from Blue Sky ADR talking to us about design liability in construction industry, a look at some key issues under JCT and NEC contract forms. Very good. Thank you so much for you all for coming, and let's receive Matthew Davies for this very nice seminar tonight. Thank you, Matthew, for coming. It's a pleasure receiving you here.
Okay, thank you very much for that introduction. Obviously, I'm Matthew Davies from Blue Sky ADR, as you know. Unfortunately, Peter couldn't be here today. He's picked up some work in Dubai that he's having to deal with, so I'm sure he's missing out. Okay, so as per the introduction today, the purpose of this evening's seminar is to look at some key issues relating to design liability in the UK construction industry. Obviously, it's a huge area, so I can't go through everything, but I'm just looking to pick up some key issues and to make you aware of some key points of some things that you may find interesting and of use to your daily lives. So when we're looking at design, the first thing we need to be having a look at is who is the designer. So traditionally, the construction industry has had quite defined roles. So it used to always be that the design would be undertaken by the client's professional team, either by an architect or an engineer, and the contractor simply builds to their design. Since the 1970s, however, the construction industry has recognised that the invaluable skills that certain contractors and subcontractors can have as part of that design process. Obviously, architects and engineers, they can't know everything, and obviously the construction industry's realised the importance that some early pre-contractor involvement can have in this process. So today's designers are not just architects and engineers, but they can be contractors and subcontractors. So one of the things that we're having a look at, if there's a problem related to design, one of the first things we're going to be having a look at, who's the designer? And it can be a multitude of people. So we've looked at who the designer is. The second thing we want to look at is, what is design liability? Well, obviously, and we've got an architect in the room today, obviously when you undertake design, you obviously also undertake a corresponding liability or design standard in regards to that design. So if things go wrong with that design, what is the liability appropriate to that person who's undertaking the design? That's what you're going to be judged by if things go wrong. So I hope this isn't one of the houses that any of you got involved with, but obviously these things happen. So in each case, the liability, the designer's design liability is to satisfy the standard design, either specified expressly in the contract or implied into the contract if the contract is silent on that. So how do designers take on design? Well, usually it's going to be in a contractor agreement. So if it's an architect, it's going to be in a consultant appointment. If it's a contractor or a subcontractor, it's going to be within their design and build contract. Somehow, however, contractors and subcontractors, which we'll come on to later, may inadvertently take on design by their conduct on site. And that's something we'll have a bit look on later on. So one of the key issues that you must understand today, and these are the key issues that we're looking at when we're dealing with contracts and we're looking either where there's problems or we're putting contracts in place, is that all designers must identify and understand their liability in regard to any design they're taking on from the very outset. What is it I'm designing and what is my liability for that design? Because as we'll come on to later, your design liability and the extent of that can have serious implications, and it can also have professional indemnity insurance implications as well. So therefore, one of the key issues today is that all designers must, before they enter into their contract, consider the terms of their contract, and also know if their contract is silent on their design obligations, what their obligations will be implied by law and when. Now, having set the background scene, it's also important, whether you're a contractor or a subcontractor or a professional designer, to understand the difference, the approach that the law will take in regard to your design liability. So first off, let's have a look at design liability of professional designers. Well, as I put on the notes, unless there are written terms to the contrary, the law requires that a professional designer, that is architects and engineers, act with reasonable skill and care when undertaking their design function. So the reasonable skill and care legal duty is either going to be provided as an express contractual term within your important, or absent an express term, there's nothing, it's not mentioned in your contract what your design liability is, the law under the Sales of Goods and Services Act will apply a term to that same effect. And as in the Binney case, 1988, not too old a case, it still says that the law requires a professional man that he live up to the practice and standards of the ordinary skilled man exercising and professing to have his special professional skill. He need not profess the highest expert skill. It is enough if he exercises the skill of the ordinary, competent man exercising his particular art. And this case comes through something that you may have heard of, which is called the Bolam test. And the Bolam test, its reasonable skill and care applies to all professionals, whether you're a dentist, a doctor, a professional designer. And this is that if things go wrong, the starting point is, under the Bolam test, is if someone's saying that you've acted negligently, and in assessing whether you've acted within reasonable skill and care, whether you've been negligent or not, it depends whether you can find a body within your profession that would have undertaken their design and their actions in the same way as you have done that. If you can, then you've satisfied the Bolam test, and you will not be found to be negligent, you will be found to have acted with reasonable skill and care. So that's what you're going to be looking for. If you're in a claim position where you've got a reasonable skill and care obligation, is can you point to a body of people within your profession who would have acted in the same way that you would have acted. And so, as I say, most appointments that professional designers are going to say are going to have an express clause in it to say that you're acting with reasonable skill and care. So if you look at the 2010 RIBA agreement, it clearly says there that the architect shall exercise reasonable skill, care and diligence in accordance with the normal standards of the architect's profession in performing the services. But a word of caution for you out there, those of you who are professional designers, don't automatically assume that my obligations within my contract are going to be reasonable skill and care. Look into your consultant appointment. It may have been amended by your employer or by a lawyer to make the far more onerous standard of fitness for purpose, which is going to be far higher and stricter, which is we're going to deal with in a short moment. And another key point that we're going to look at today is that if you do have a fitness for purpose obligation, you need to look at that in the contract before you sign it and resist it if at all possible. And the reason for that will become obvious very shortly. So we've had a quick look at the design liability of professional consultants, and as we've said, unless there's an express term saying that it's fitness for purpose, then generally your design liability is going to be reasonable skill and care. For those of you who are contractors, however, It's very important, and another point for you to take away, that there's generally going to be two design liability standards that you may come up against. This is, you're going to have, as I've just mentioned, the more higher, onerous and strict obligation of fitness for purpose. Or alternatively, you're going to have a duty to use reasonable skill and care in undertaking your design function. Which one applies? Well, this will depend on the terms of the contract. So what is a fitness for purpose design liability obligation? We've already looked at what a reasonable skill and care one is. What is a fitness for purpose obligation? Well, it's a far more higher onerous design obligation. It's determined by the usefulness of the finished product. A fitness for purpose obligation is, does the design comply with the obligation that was reasonably brought to your attention at the time? It's a strict liability. It matters not a jot if you're under a fitness for purpose obligation whether you've used reasonable skill and care. It's strict. So if you're a contractor and you're under a fitness for purpose obligation and you must achieve certain lighting levels in this room, you must achieve certain airflow rates, you've either achieved them or you haven't achieved them. It doesn't matter what skill, care or effort you've put into it, it's a strict obligation. It's far more higher and onerous. And as I've put on there, it's effectively a guarantee that the finished project will be fit for its intended purpose. So, contractors and consultants, as I've said out there, one of the key issues is that fitness for purpose obligations should be identified and resisted during the tender pre-contract negotiations. So how may a fitness for purpose obligation arise if you're a contractor? Well, first of all, unlike professional designers, your starting point is that if you're a contractor and your contract is silent on the design liability for the design that you're undertaking, the law implies as a contractor that your design liability will be fitness for purpose. And that's very important. And this is one of the cases, say, we're going to come on to it in a moment, is IBA versus EMI. 1980 case, went all the way to the House of Lords. And the court here said that where the contractor duly undertakes design and there is no express reasonable skill and care obligation clause in the contract, then the implied term will be that the contractor is obliged to ensure that the finished work is reasonably fit for its intended purpose. Now, this was a landmark case. In 1966, IBA, it's the Independent Broadcasting Authority, engaged EMI to design a cylindrical television mast. It was 1,250 feet high, and nothing like this had ever been built anywhere in the world. There'd been some smaller ones built in America, but this was a huge, massive television nest. It was at the frontiers of known knowledge at that time. Nothing like that had been built. In 1966, it was handed over. In 1969, the mast collapsed. They found out that what actually happened was it had its height meant that the wind was making it constantly shudder, and then combined with it was so tall it had certain times of the year it had the weight of ice on the top, and gradually it caused problems, it fractured and it snapped. So, as in all of these things, you've got to realise that employers generally, when you're faced with a claim, a design liability claim, the employers will put everyone into the court. It will put the designers, it will put the contractors in, and it will let the courts sort out who's responsible and to apportion responsibility. So, IBA have brought a claim against EMI, and EMI said, well, hold it a second. We have viewed, this is right at the frontier, no one's ever designed anything like this. We've used all the skill and effort. They'd even gone to one of the leading universities and had structural calculations done. to get this mast to work. They'd undertaken all due diligence. They produced lots of evidence. And the Court of Appeal said to them, yes, there is no doubt that you've undertaken reasonable skill and care in producing the design of this mast. You couldn't have done anything. But it matters not a jot. You were under a fitness for purpose obligation. Is the mast fit for its intended purpose? Well, clearly it isn't, because it's lying on the floor broken. And they were liable under this strict obligation. So, we've looked about the first way a contractor could take on a fitness for purpose obligation, and that's where his contract is silent as to his design standard and liability. The second, more obvious one, is where there's an express fitness for purpose clause in the contract. And this says, maybe something as simple as this, I'll put you an example on. The contractor warrants to the employer that the works will be fit for their purposes as made known to the contractor by the contract. So that's pretty easy to pick out. But obviously, you've got to realise that fitness for purpose obligations can be hidden more subtly within the contract drafting. It's also important that you may check that your main contract says you're under a reasonable skill and care obligation, but also check the ancillary contracts to that. It has been known for warranties that you've then got to provide to the employers or tenants that when you look at them, actually have a fitness for purpose obligation in them as well. So you need to thoroughly check as a contractor that you're not taking on a fitness for purpose obligation. Unless you're prepared to, of course, but for reasons we'll come on to, it's not recommended. So what is the third way that a contractor can take on a fitness for purpose obligation? Well, I always call this the helpful contractor, or we're too busy to wait. And the issue that we have here, I'll give you an example. When I first started working on site, we were building, we're on two existing buildings. It was a big leisure complex, and we were infilling the middle building, putting a new steel frame, matching it in, and it was all going to become one building. Now I can remember that on the one side, the steel frame was going in and it was on hold for a long time because we were waiting for the structural engineer, the client structural engineer, to complete the design for the last few beams that were going to tie into the column. And I remember one day the young site manager came on site and he said, you know what, we can't wait anymore, we're in delay, we've got an extension, you know, we're not getting an extension of time, I've gone out there, I've measured the steel, I've drawn it, and I've given it to the steelwork contractor, and the steelwork came down and we fitted it. Fortunately, there wasn't a problem. But just imagine if there had been a problem. Were we down to design that steelwork in the contract? No, we weren't. It was meant to be the employer's structural engineer. So say that there'd have been a crack, say there'd been a building failure, and when it had been investigated, they'd have found out that actually it was these steels that the contractor put in that caused the problem. What do you think the architect and his employer's design team would have said? Well, we didn't design those. So the contractor would have designed them. Now, he wasn't down to design those steels. So what do you think his design liability would have been? Well, it would have been fitness for purpose because he wasn't down to be designing those. And one of the problems with the fitness for purpose obligation, I could always imagine in my mind as the construction manager was travelling back to tell the directors that actually the reason for the building collapse was the steels that we'd designed. It didn't happen, by the way, but I'm just giving you the scenario, is that many professional indemnity policies specifically exclude fitness for purpose obligations. They view it as an absolute too onerous obligation. They will only cover you for reasonable skill and care in the main. So you could imagine if this building had collapsed because of the steelwork that the contractor had put in, he would have then had to explain to the directors, well, that was something I designed that we weren't meant to design. And also, they probably weren't going to be covered by insurance. So these are one of the reasons that you've got to try and, if you've got a fitness, try and identify fitness for purpose obligations and resist them. So, contractors out there, or specialist subcontractors, if you want to avoid having an implied fitness for purpose obligation, one thing to take away today, you must make sure that the contracts that you enter into expressly state, they're not silent on it, they expressly state that your liability for the design that you undertake is that of reasonable skill and care. And that's exactly what the JCT contracts do. So if there's a problem, you're going to be judged in comparison to the standards of the average competent professional designer. And why is this? Because if you're a contractor or a consultant, but if you're a contractor, you're in a far stronger position to defend a claim that's brought against you where the claim is that of where your design liability is reasonable skill and care. The employer must prove your negligence, as I put on the slide. Reasonable skill and care does not guarantee a particular result. It's the effort that you put into producing it as much as the result that's produced. And the contractor only has to show that he acted with reasonable skill and care and of an ordinary competent designer to show that he hasn't been negligent in defending a claim. However, if you're under a fitness for purpose obligation, there's no need for the employer to show that you've been negligent. In respect to the claim, the employer will simply have to point to, as we showed in that case, does my room produce the heating outputs that he was required to produce? Does the design perform as it was required to perform? And it's either a yes or a no, strict liability result. The skill and effort that you used in a fitness for purpose obligation is no defence to the contractor. Also, as I've said before, you need to, as a contractor particularly, make sure that all your design obligations are back to back. So, as the main contractor, if you're passing down design to a subconsultant, you need to make sure that your design obligations are back to back. So, for example, the NEC that a few of you know and love in this room, the starting point in an NEC contract is a fitness for purpose design obligation as a contractor. You specifically have to, first thing I'm checking if I'm working for looking at an NEC contract, has option X15 been selected? Because if option X15 hasn't been selected, the contractor's design liability is fitness for purpose. You have to positively select option X15 to make it that of reasonable skill and care. But the professional skills contract is which you'll give to the subconsultant, is reasonable skill and care. So you want to make sure your design liability obligations are back to back, because if I'm the contractor in that particular basis, if I'm under a fitness for purpose obligation and there's a problem with that design and I have a claim against me, I then want to go and pass it on to my consultant. Well, if I'm under a strict design obligation and he's under a reasonable skill and care obligation, I could end up holding the problem, because as long as he can show he's exercised reasonable skill and care, there'll be no claim against him, but I'm under a strict fitness for purpose obligation. So this is where I'm trying to say, when you're signing up to contracts, you have to make sure, ideally, that everybody's under reasonable skill and care. So you're all under the same design obligation. But if you as the contractor are under a fitness for purpose obligation, it's very unlikely that your consultant's going to let you say, actually, will you be back to back with me on a fitness for purpose obligation? You're not going to be passing down your obligations down the contractual chain. And as we said, this can cause major problems with professional indemnity insurance. So, The summary for this part of the seminar is that it's very important that you understand the difference in design liability that the law can impose upon you where there isn't an express term within your contract. Professional sorts of architects and engineers, their design liability is generally going to be reasonable skill and care unless they sign up to a contract that says it's fitness for purpose. Design contractors and subcontractors, beware. Unless your contract specifically says that your design liability is reasonable skill and care, it is going to be fitness for purpose. So therefore, top tip today is in your professional lives, if you're entering into contracts and signing contracts, one of the first things you should be checking if you're designing is what is the standard of my design liability within the contract. Okay, so we're now going to just jump on to the next part, and I'm going to have a look at some key issues relating to the NEC, a few key issues relating to NEC and the JCT contracts. These are things I generally get phoned up about quite regularly, or we have to deal with, or things that we're looking for in the contracts. And as I said at the start of the seminar, that from the 1970s sort of onwards, you know, there's been a prolific use of specialist subcontractors and contractors within the design process, early contractor involvement, getting them to bring their skills in. And obviously, the standard forms have recognised this fact, and I've got a JCT and an NEC contract somewhere in the room. They should be being passed about to you if I could have them back at the end. But they both undertake a different approach. So let's have a quick look at the NEC3. Well, the contractor's position under the NEC3, and I'll call it the NEC3, it's the EEC, but I'll call it the NEC because that's what everybody knows, is different to the JCT. First off, it does not have a specific design and build contract. It's one contract fits all. And it's far less prescriptive in its drafting as the JCT. The JCT contract probably has about 5 or 6 pages on, you know, design responsibility, responsibility for the employer's requirements, responsibility for this, responsibility for that, statutory requirements, etc. Whereas the NEC is far more simplistic in its approach. Core Clause 20 merely provides that the contractor provides the works in accordance with the works information. And Clause 21 simply states that the contractor designs the parts of the works which the works information states that he is to design. So this contract is heavily reliant on what's in the accompanying works information. So really, if you've got a design obligation, that's where you need to be looking at and focusing your attention to see what the design submission procedures, see what it is you're designing, you know, what is the extent of your design as well, because you might only be designing discrete parts. You know, you need to know what is the limit of your design responsibility, not just your liability if it goes wrong, but, you know, make sure you're operating within the confines of the contract. And as I said earlier, Clause 20.1 means that the works must comply with any purpose specified in the works information. And the guidance notes are quite clear to the NEC3. Without X15 being chosen, the contractor's design liability is fitness for purpose. Well, if you're not savvy with an NEC contract, are you really going to be looking to make sure that X15 has been chosen? And it may not have been. But you must, unless you want to take on a fitness for purpose obligation, you must make sure that X15 option has been selected. And the design documents, as I said before, is the works information. And that's going to be broken down into 2 parts. it's going to be the employer's works information, and where the contractor's designing, obviously he's got to produce how he's going to satisfy with what the employer wants him to do. So he's going to be producing the contractor's works information in respect of the bits that he's taking design responsibility for. And they all end up in the contract data, which is in the NEC contract. And there should be no ambiguity or inconsistency. So for those of you who coordinate design, if you're getting involved with an NEC contract, you need to make sure that the employer's works information and the contractor's works information fit together. And this all has to be identified pre-contract, because if the contractor's works information contains a different proposal to that that's in the employer's works information, once you've signed that contract and you've started, it will say that the employer's works information has priority. So if you're a contractor and you've priced a cheaper alternative and that's been agreed to by the employer, you must make sure that the employer's works information before you sign the contract is amended so that they're both back to back. Otherwise, it could end up costing you money. We've had a very quick look at the NEC in that respect. Under the JCT, which, as Peter Barnes said last week, is still the most popular contract in the UK, purely because we've all been brought up, most people are familiar with it, ease of use, so people tend to go for the tried and tested. It's still about 60% of contracts in the UK. Unlike the NEC, it produces a suite of contracts. So it's going to have contracts where the contractor is to complete the entire design of the works, or it has, which is you've got the design and build one floating around there somewhere, and it also has contracts where there's still a designer producing the bulk of the works, but it may be that you're using the contractor to design discrete elements of it. Structural steelwork connections are quite common, or it might be just the M&E services. So you've still got the architect designing, say, quite a bit of the work, but you're using the contractor to design discrete elements. And those are the contracts used there. It's the intermediate, the standard, and the minor. What I'm going to focus on today is the clauses are very similar in all the JCT contracts. There may be some sort of differences, but rather than that, I'm just going to focus on the clauses that are in this contract. And as I say, I brought that contract with me, and that's in the back there if anybody wants to have a look at it after. So unlike the NEC3, the JCT's approach is that the design liability of the contractor should be reasonable skill and care, and the contract expressly states that. It says at clause 2.17.1 that the contractor shall, in respect of any inadequacy in any such design that he produces and responsible, have the like liability to the employer as would an architect, or as the case may be, other appropriate professional designer. Okay? So they're expressly stating that it's reasonable skill and care. So you can see it's a different philosophy from the NEC straight away. And the reason for that difference in philosophy, I'll just add, is that the NEC3 views itself more as an international contract. So they're saying that in some jurisdictions, the employers there may have no problem with a fitness for purpose obligation. But obviously in the UK, when it's been used in the UK, it does raise certain issues, as we say, the strict obligation that will bring upon the contractor. Right, so the JCT has quite standard reasonable skill and care clause specifically put in there for contractors. That doesn't mean to say as contractors you should still open up the contract and check that it's still there, because these clauses can be amended. You should always read what you're signing up for. And one of the amendments that the employers commonly seek to do is to beef up that clause 217.1. So if I've got an architect designing the gherkin, for example, do I want, if there's a problem on that, to say, well, as long as you can show that an architect who designs, extensions on houses would have done it in the same way as you've done it, then you're not negligent. Obviously, employers are not going to want that. So they're going to sort of narrow down the comparators if there's a problem with who you're comparing the designer's obligations with. So you may frequently get an amendment to that clause that says, insofar as any design of the works is required to be carried out by the contractor shall carry out and complete such design using all the reasonable skill and care to be expected of a properly qualified and competent professional designer who is experienced in designing the works of a similar nature, value, complexity and timescale, and in a similar location to the works. So what it's trying to say is that it's still a reasonable skill and care obligation, but it's narrowing down the field of those designers that you should be comparing your skills to. It'll be other people who are used to, designing skyscrapers, in the particular example that I've given. However, as I've said before, fitness for purpose obligations on contractors, even when those a reasonable skill and care clause is in place, can still arise. Firstly, where the contractor assumes and undertakes design that is not required to do under the contract, that can cause a problem. And also where the contractor's designing its temporary works, such as scaffolding, propping, etc. The law is quite clear that has to be a fitness for purpose obligation because, if scaffolding collapses, it's a serious health and safety issue. You don't want a contractor to say, all those people have been injured or killed, but I designed it using reasonable skill and care. The law is quite clear that, things like scaffolding and propping, temporary works, not the permanent works, are going to be a fitness for purpose obligation on the contractor. Now, under the JCT contracts, the design documents are going to be basically terms that the employer's requirements. So that's going to be the employer's instructions to the contractor about what he wants him to design. And they're going to be, and in response to that, we're going to have the contractor's proposals. So this is the contractor saying how he will undertake and complete the design that the employer wants him to do. Now it's important to remember, this is where I was coming back to the scope, that the employer's requirements can be anything from a couple of pages saying we want a hotel, it's got to be 8 stories, it needs 250 car parking spaces, get on and design it. So the contractor's going to be taking on quite a broad and wide design obligation in completing the design. Or it may be something where, as I see quite a lot, that the employer's requirements are virtually the entire design. Folders, files and files of specifications and drawings, where the contractor is only completing a very limited design input. And whilst the JCT can be amended for single point responsibility, in its unamended form, the JCT's philosophy is, and it's quite clear, that the contractor is only completing the design. He's not undertaking all of the design, which a lot of people think on site. He's merely completing the design. That's an important point to take away today. And one of the big things that it'll be is that, and it comes up quite a bit on site, is the contractor responsible for any errors or obligations in the design in the employer's requirements? So he's completing the design, but the base design in the employer's requirements, is he responsible for any errors or inconsistencies in that? And the answer to that is no in the unamended JCT contract. It is quite clear that other than for compliance with the statutory requirements, the contractor is not responsible for the employer's requirements or for verifying the adequacy of the design contained within them. You need to check that clause as a contractor because that's often amended by employers and you may not be happy with that. The JCT's philosophy is quite simple. Whoever's produced that design should be responsible for it. So the design in the employer's requirements should be the responsibility of the employer. The design in the contractor's proposals should be the responsibility of the contractor. And there was an important case on this. It was called the Henry Boot versus a Cooperative Society. And what happened in this particular case was that Henry Boot were building the co-op's headquarters. It was a new office. It was under a JCT. It wasn't a full design and build contract. It was a traditional contract. And one of the design section supplements wanted them to complete the design for the basement. What actually happened was that Henry Boot completed the design of the basement, it built it in accordance with the employer's requirements, the contractor's proposals, and it leaked. And the co-op took them to court, and Henry Boot's defence was, well, hold it a second, you know, look at the design was all there. Our design liability, basically, we were just producing working drawings because all the design was there. Now, this clause wasn't in the earlier JCT contracts. It came in from the 2005 forms in response to that case because Justice Seymour, sitting in the Technology and Construction Court, said, no, even though you're only completing the design, you're responsible for verifying and looking into the adequacy of the design in the employer's requirements. And at the time, that sent a shockwave through the construction industry. That's not what people envisaged the JCT contracts to be about, nor did the JCT. And as a result, it introduced that express clause into the contract. So when I'm vetting a contract for a contractor, one of the first things I'll do is I'll check, is that clause still in place? Because it's often amended or deleted. If it's deleted from the contract, for example, you're going to be going back to the Henry Boot case position. But as I said in that clause, it says that other than for compliance with the statutory requirements, you're not responsible for verifying the adequacy in the design in the employer's requirements. So what does that mean? Well, what the contracts do in the JCT contracts is that they say that contractors out there, you know how to build, you know what the statutory requirements are. You know, you should know, you know, what's the height of balustrades, what's for windows and all these sort of things. So what the JCT states that if there's a problem in the employer's requirements that relates to the statutory requirements, then you will be responsible for correcting those at your own cost because you're meant to have an inherent knowledge of the building regulations and things like that. The only exceptions under that clause where you won't be responsible for is where the discrepancy arises because of a change to the statutory requirements after the base date. So all of these contracts, you write in what the base date is for the contract. So if all of a sudden you're putting in balustrades and after the base date in the contract, the regulations are changed to change the height for it, then that will be a variation, it's recoverable. Or if the contractor's proposals need to be changed because of a change in the planning conditions after the base date, then you can recover that as a variation. Or the last one, and I've never seen this in my life, I'll be happy if anyone can tell me they have seen it, is if the employer's requirements expressly state that they comply with the statutory requirements. I don't think there's going to be many professional designers going to be putting that within their employer's requirements, but who knows? So we've looked at the design liability, we've looked at how it deals with problems within the designing the employer's requirements or designing the contractor's proposals and how the JCT deal with it. Well, what if there's actually a discrepancy in the employer's requirements themselves or the contractor's proposals or between the two? And these often crop up, particularly where you're looking to claim variations or changes. So first off is, well, what if there's a discrepancy within the employer's requirements? So, for example, we look at the employer's requirements and we see in there that the employer's requirements in one part say that in the boardroom and offices there's going to be oak skirting. But then we look later on in the employer's requirements, it actually says cheaper MDF skirting. What is the contractor going to comply? Well, the contract deals with this, and it says that if the contractor's proposals deal with this, then that will apply. So it would be MDF skirting. But if the contractor's proposals do not deal with the discrepancy in the employer's requirements, well, the contractor gives his proposal as to what it should be, but whatever's instructed is going to resolve this discrepancy in the employer's requirements is going to be treated as a change and a cost to the contractor. What about if there's a discrepancy in the contractor's proposals? So we're building a hotel and we note in the contractor's proposals that in these rooms, in the bathrooms, one says shower room only, and in the other part it says no, there'll be a bath with a built-in shower. Which applies? Well, again, the contract deals with that in the JCT contracts, and it will say that the contractor has to put forward his proposal to resolve the discrepancy, and the employer can choose to accept that proposed amendment at no additional cost to the employer. So likelihood is, for example, he says, no, I want the bath with the shower in it. If the employer then comes back though and says, well, actually, I want something completely different to that. I want a bath there and a shower there and a bidet there. I've decided to completely redesign it. Then that would be an additional cost to the contract. But that's rarely going to happen. The employer's going to say, well, no, that's what I want, and that's within the price that you've submitted. Now, the big area where these contracts, and the JCT's criticised for not dealing with it, and this is the main common area, and that's why I'm raising it as an issue today, is where there's a divergence between the employer's requirements and the contractor's proposals. So the employer's requirements say we want this solid gold toilet, which I assume most of you have got at home, thousands of pounds. And the contractor's proposals say, no, we've allowed for a home base, £100, cheap as chips toilet, that's what we're putting in. Well, the contract is not entirely clear, nor gives a specific answer. But the general held view is that the employer's requirements will take precedence. Now, the contractors in the room will argue, and I've argued it myself, well, hold it a second. The third recital of the design and build contract clearly says that the employer has examined the contractor's proposals and is satisfied that they appear to meet the employer's requirements. So you've accepted it, so let's put the white toilet in. Well, no. If you look at it a bit further, the generally held view is that the contract supports the employer's requirements taken view. The first thing is that footnote 3 to the third recital says that any divergence accepted by the employer should be shown in the employer's requirements. So he clearly hasn't accepted it, because if he had accepted it, he would have scrubbed out the gold toilet and put in the white toilet. Also, when you start looking at the terms of the D&B contract itself, it talks in terms of the precedence of the employer's requirements. You issue instructions making a change to the employer's requirements. You issue, it's the employer's requirements, not the contractor's proposals. So the tip for today is that those contractors who are producing their tender and they're looking to gain a commercial advantage, and they may agree with the employer, let's swap this for this, we can put this in our contractor's proposals, we can put a white toilet in instead of a gold toilet. Before you sign that contract, you must, as this footnote says, make sure that the employer's requirements are amended to reflect what you've priced and agreed for. Because if they don't, you may find yourself having a problem later on. The other thing I commonly see is where there's been a problem and I see subcontractors or contractors say, oh, it doesn't matter though, because he's approved my drawing and therefore he's taken on responsibility for it. Well, the answer for that is no. Generally, approval of the contractor's design does not remove the contractor's obligation to ensure that the design meets the required standards. And both the JCT and the NEC, clause 14, put express clauses into that effect. But caution, those of you who are responsible for checking the contractor's design, don't leave here today and say, well, it doesn't matter then, I'll just keep on stamping them away, you know, I'll be on the phone, stamping the drawings, doing this. You can't do that. You've still got to check these drawings are part of your obligation of reasonable skill and care to be looking at them and seeing if there's problems. Because, as I've said to you before, if there's a problem, a claim related to a design issue, the employers are basically going to put both you into the courts and let the courts sort it out. And if it was a glaringly obvious error in that design that the designer should have picked up that's now cost the employer money, you could end up finding that you're liable to contribute towards those costs as well. It might be 20%, might be 30%, but this is what I'm trying to say. Just because you've got these caveats to say that it doesn't affect the employer's, the contractor's liability for the design, if you're approving them and it causes a problem later on, you must still do your due diligence when you're looking at these drawings. It's also important for those of you who are getting involved in the design process is that if there's a design submission procedure, you understand the rules of the game and you apply the rules of the game. So the JCT at Schedule 1 to that contract have a design submission procedure. Read it, know it, understand it. Has it been amended? So if we have a quick look at the JCT one, it clearly says the contractor must submit all design documents that it prepares for review to the architect or the contract administrator. Following their submission, the architect then has 14 days and the documents have to be returned to the contractor graded as follows. A, the contractor is to proceed with the works in accordance with the design document. Well, how many contractors in this room know that the default position is if they're not returned to me within 14 days, they automatically get grade A status? And I think there's a few designers who are not aware of that as well. Or they're marked B, proceed with the works in accordance with the architect's comments. So you can carry on with the design, but you must amend the design to take on board the comments that are on your drawings. Or C, the contractor is to resubmit the design documents incorporating the comments made and no works are to be carried out. Well, it's important that you know the rules of the game as well, because the contractor is only entitled to be paid in respect of such work where they've obtained A or B status. So if you're proceeding with documents that have been returned to you marked C, you're proceeding at risk. There's also the same sting in the tail for contractors. Just as professional designers must return them within 14 days, first thing you should be looking at if you're a contractor is when you get these drawings is saying, are any of these comments a variation? So some of these comments may not relate to your design. There may be changes. You know, I don't like that now. Can we do this? Can we do that at additional cost? And you've got to pick those up straight away, because the design submission procedure says that if you don't challenge them within 7 days, those comments, then they will be deemed to not constitute a variation. So the contractors have got to be on board as well. So all parties, whether you're doing a design submission here or elsewhere, it's important that you know the rules of the game and how it applies. These design submission procedures are important. They're to get the job flowing, to get the design moving, to get the design looked at, and they have to be operated correctly. The NEC 3 says that C is to submit his design to the PM for acceptance. There's no process in the contract for a design submission procedure. As I said, the NEC is quite sparse, but commonly there'll be a design submission procedure in the works information. So again, crack that open and understand it. And again, clause 21.2 is quite clear that the contractor is not to proceed with the relevant works until after the project manager has accepted that design. So you've got to be working within the realms of the contract. As I mentioned before, clause 14.1 is clear that despite acceptance, the contractor remains responsible for providing the works and for the contractor's design. So the fact that he's accepted your design, the contractor still remains responsible for that design and his design obligations. The very last area that I'm going to have a look at tonight is the duty to warn. So where we've got consultants out there, where we've got contractors out there, and they are designing the work, where we've got contractors who don't have a design responsibility, and they spot a design defect within the architect's design, do they have a duty to warn? Well, unfortunately, I'm for want of a better word, embarrassed to say, this is still a very difficult area. As I've said in there, the extent of the duty to warn is a grey area under English law and is unsatisfactory. There are some common principles, however, that I will try and go through today. And that is, first off, historically, there is no duty imposed by law, but the duty can arise upon contractors in particular circumstances. But those circumstances aren't clear. It's been developed in a number of cases. It's still open and it's still developing. So it was historically thought that if the contract expressly states that the contractor has no design responsibility, then there is no general obligation to notify the architect if there's a problem that you notice within his design. I've no design responsibility, I don't need to tell him. But be very careful. The case law today has shown that that duty can arise in particular circumstances. It's fact-based, and whilst there might not be a case covering it today, your particular circumstances, there may still be a duty brought in place. So some of the principles is that first, the contractor may have an implied obligation if a special relationship exists between the contractor and the consultants, if there's some reliance. Now that's going to be rare, but there have been a couple of cases on that. One's a Canadian case. I'm not going to dwell on that too much. The more interesting point is that where the errors are obvious and the contractor deliberately decides not to bring those to the attention of the architect, then that liability may result in that the courts may find that the contractor had a duty to warn in certain areas, a part of his obligation as a contractor to exercise reasonable skill and care, not in his design, but how he undertakes his works as a competent contractor. And that is going to be particularly the case if there's health and safety issues. And I've got a couple of examples, but as the Court of Appeal stated, that implant is that where an experienced contractor is involved and the design of the works is not only defective, but obviously dangerous, there is an overwhelming case that the contractor is bound as part of his obligation to use appropriate skill and care to warn a client of the danger it perceives. And there's going to be two cases I'm going to put you on that are more recent. The first is the Lindenberg case versus Joe Canning in 1992, quite a relatively new case when you're my age. But what happened in that case is that the contractor, and I believe it was in a flat in Camden, was converting and doing basement works to a basement flat. Now, the employer's surveyor gave him some drawings showing walls to be knocked out and a chimney breast to be taken out. And I believe that the drawings also showed that these were 9-inch thick walls, showed them to be non-load bearing. Well, any contractor worth his salt would have known that 9-inch walls are generally load bearing walls, and particularly it's a chimney breast. But the contractor thought, well, I'm not responsible for design, why should I care? So he didn't prop it or anything, he just knocked these walls out, caused substantial amount of damage to the walls below. So what's happened is the employer has taken his surveyor and joined the contractor in the action to recover his costs. The contractor said, well, you know, I've got no design obligation, I have no duty to warn, I don't, you know, there's, you know, the wall said they were non-load bearing, that's his problem, not mine. And the court said no. Any reasonable, skilled and competent contractor exercising that in the works that he's undertaking would straight have known that it's obvious that 9-inch thick walls are going to be load bearing. You should have raised that issue straight away with the other side and said to them, you know, there's a good chance that these walls here are going to be load bearing. Do you want to check? So he was found to be 20% liable for those costs. So he had a duty to warn because of the danger. The second case as well, which was 1999, these, you know, the case laws is littered with design obligation issues. In plant construction versus Clive Adams and another, it was actually, I think the quick name was JMH. This was quite an interesting case that Ford, in its development and research plant in Essex, was having some works undertaken. And what it wanted to do was to extend its research facility and undertake some amendments to it. And part of that was it wanted some new engine pits built. The trouble is that one of these engine pits that was being put in involved where the main roof column came down, supporting most of the roof, it required it to be propped while these works were being undertaken. Now, Plant sublet out that element of the works to JMH, who were undertaking those works, but their contract said that you have to take and comply with instructions from Ford's engineer. Ford's engineer negligently said, no, you'll be fine to prop that main roof column with acro props. And JMH said, well, no, this isn't going to work. We need to have more proper, you know, this has to be properly and adequately supported. Acro props are not going to work. But he was insistent, that's what I want doing, and that's what you'll do. 2 weeks later, under heavy rainfall, that roof collapsed under the weight. The propping was inadequate, and it caused over £1 million worth of damage. Fortunately, it happened at night when it wasn't occupied. If it had happened in the day, then the court was concerned that would have definitely been loss of life or damage. So obviously, JMH, the subcontractor, are in court. They're having to defend what had happened. And they said, well, look, we warned them. What else could we do? We warned them. And the court said, even in that case, which is the whole reason this area is still developing and vague, is, well, no, you're still liable because in those instances, you should have vigorously protested or even walked off site when you knew there was going to be such a danger. Well, what they also didn't deal with the issue was, would a contractor still have a duty to warn if it's just an aesthetic issue? So it's not a dangerous issue, it's just, you know, that design isn't going to work, but it's not a health and safety thing. And the court helpfully deferred that to a future case. What we're looking at here is that it's going to be a problem because the whole area of the duty to warn is uncertain, because each case is going to be fact specific. So in this case, the health and safety issue may have caused the loss of life, but there can be other health and safety issues. What does the contractor do? Obviously, you've got to warn, and it's got to be in writing. But if it's then going to be, what does the court mean by, you must protest in vigorous terms? These contracts, if you suddenly walk off site and you don't have good grounds, the employer can terminate it. So you're in a quandary. So obviously, what you should then be doing is getting in your duty to warn. Make sure it's in writing, but then depending on how serious it is, I would suggest that you take legal advice, because if it is a serious health and safety consequence, you don't want to be carrying on, because better to face having the contract terminated than a corporate manslaughter charge against you. But as we say, that's at one end of the spectrum. What do we do at these other ends of the spectrum? How, what is the extent of our duty to warn? What if it's just an aesthetic issue? And my advice to be is that contractors out there, if you know there's a problem with the design, whether it's just aesthetic or something's not going to work, and certainly if it's just a health and safety issue, make sure that you warn and make sure that you put it in writing. Bring it to the other party's attention so you're covered as far as possible. But I've said, even in this present day, we have no specific guidance from the court. Okay, we're at the end of our talk now. Hopefully you can appreciate we've gone through quite a bit of issues here now. There's a few key facts, hopefully, that you've taken away. Differently between what is the difference of design obligations between a professional consultant to a contractor, the problems with fitness for purpose and insurance, understanding the contract, reading your contract. Are you responsible for discrepancies? Are you responsible for designing the employer's requirements? All the way down to the problems. If there's problems on site, make sure that you get your duty to warn in and make sure that it's in writing. If there's a design submission procedure, make sure you understand what that is, make sure you comply with it. Obviously, I can't go through everything today, but I hope those are a few of the common things that in your daily lives you're going to be coming across with. So that's it, unless anyone's got any questions.
Thank you very much, Matthew. Thank you. I learned a lot today. I think with my site experience, this is the kind of claim that will always come up. It's the most common type of claim is on design liability. So thank you very much. Questions?
Thank you. I would like to ask you about design life and how long does design liability last if there is design life stated in the contract, and if there is that's not stated in the contract. So if, for example, and I would focus on structural design liability.
Yeah, well, you're looking at the limitation of action. So the limitation of actions are going to be that if a contract's signed under hand, then usually it's 6 years from practical completion. If it's as a deed, and usually it's 12 years from practical completion. So that's why in a lot of cases, excuse me, you're going to be looking to get contractors to sign up as their contracts as a deed, but also as contractors, when you're passing your entering into your subcontracts, if you're under a deed, you also want to make sure that your subcontractors assign that as a deed, because you don't want to be finding there's a design issue, as a design problem in year 8 of the contract, and suddenly find out, oh, I've signed up the contract underhand for the subcontractors, and the 6 years has expired for him, so I'm on my own. There can be, and I'm not going to dwell on that here, but if there's been things where there's known design defects and the contractors covered them up, then that might extend under tortious liability for slightly longer, can be up to 15 years or more, depending on the circumstances. But that's tended to be if there's been, you know, something untoward, something like that. So.
Thank you very much for the talk. I just have a question in that, in aspects where you've got a traditional contract, but within that traditional contract, there are some aspects that have been introduced as contractors' CDP. Where then does the architect's liability stop, and when does the contractors kick on? In that, at times, for example, like today, I was involved in a CDP meeting where the contractor is obliged to design a retractable stair. We've had a meeting with the supplier or the manufacturer at our office, and there have been a few design tweaks that have been necessitated with the better efficient working of the retractable stair. The contractor's representative was on board and participated in the discussions, but so far as us as a practice, as an architectural practice, where does our liability stop?
I can't discuss specific cases without knowing, but I can talk general principles. And I think what you're trying to say is that, and what I see a lot of things happen, is that the contractor will go, there's a problem here with the design. And the professionals will say, well, you're designing it, it's down to you, it's your problem. And that's probably the point that you're making. And then someone like me will turn around to the professional and say, well, no, actually, the design problem's in the employer's requirements, so it's down to you, because I'm not responsible for verifying all the adequacy of that, so therefore it should change. So if I'm looking to say, well, I'm designing this bit here, but this bit here can't work because there's a fundamental problem in the base design in the employer's requirements. You see, you've got to realise, under the JCT contracts, the contractor is only completing the design. Now, this is what I was trying to say is, how much is extending the completion of the design depends on how big or small the employer's requirements are. Now, what may happen, particularly in the recession, is that lawyers amend these contracts to say that the contractor takes on board the entire responsibility for the design, including that within the employer's requirements and including that within the contractor's proposals. But a lot of contractors won't stick for that because they're going to say, well, hold it a second, the architect's been designing this for 8 months, or you might say, I haven't had 8 months. I've had 2 weeks to price it, and all of a sudden, I can't be responsible. I don't know what's happening with the design there. The other area that you might find is that people commonly say, well, hold it a second, if you look at my specification, so you've got to write in the contract what the contractor's design bits are. So you'll say, the works are da-da-da-da, and then you'll look further in the contract in the JCT and it says, and the contractor shall complete the design of, and you might say M&E, structured things like that. It's quite common then, I find, for people to say, well, hold it a second. My specification is far wider than that. It says you're responsible for contract design for this, you're responsible for contract design for that. But the contract is quite clear under clause 1.3 because under normal terms, the specific, under the canons of construction, the specific overrides the general, and the general is the standard form. Now, the JCT specifically to overcome that, at clause 1.3 that says nothing in the specification or supporting schedules shall override or modify the terms and conditions in this form. So, if you want the contractor to have certain CDP, you've got to make sure that what's in your specification is written into that thing, otherwise you're going to have a problem. Has that answered your question? Yeah.
Sorry, I've got one. It's not really a question, but it's something that I think maybe you might be able to help me with. Thank you very much for your workshop presentation. It's kind of helpful. It's a term that we normally use we all normally see in contracts most of the time, and you did mention fitness for purpose. So what does that actually mean? fitness for purpose, is there any like key stuff that actually makes people understand what fitness for purpose is? Because I think it's just a very ambiguous term that has been used that sometimes it does actually drag into claims which you already touched on earlier on. So,
well, it's not. It's fitness for purpose is an absolute strict obligation. It's fitness for purpose of that design has to be fit for its purpose as reasonably made known to you. You can't suddenly be, oh, actually I wanted it to do this. But if it's reasonably made known for you, it's strict. Reasonable skill and care is about effort in producing that design. It doesn't guarantee the end result. If you've got fitness for purpose obligation, you're guaranteeing the end result. So if your specification, and I give it, is, as we all know in designing rooms, is particularly with M&E, getting the room changes, the heating and things like that. If you're under a fitness for purpose obligation and the specification says this room will do this and will do that and will do this, and it's got to comply. It's got to do, as Ron Searle says, it's got to do what it says on the tin. And if it doesn't, you've got a problem.
Is there any other way to measure that? Because although the client probably might have stated that in his requirements, but then again, they can also turn back and say, well, this is not specifically fit for purpose. So is there any sort of way of measuring the term fit for purpose?
Well, yes, you look at the contract and what does it require you to do. But, I would hope that what you're taking away from today is that when you're looking at contracts, first thing you should be doing is saying, no, it's reasonable skill and care. Because if you're not insured as well, not only have you got a problem, you're not going to be insured, are you? It's too absolute obligation. I don't know what time you're going to say that, materials are going to be fit for purpose because they're to produce something, but you're talking about your design, it's talking about, the reason the law is more biased towards contractors on this fitness for purpose obligation, and I'm sure our friend at the front who's an architect won't agree with us, but it's done by lawyers, that the law looks at architects as they design, they're professional people, but they don't build. So it's reasonable skill and care. The law looks at a contractor to say, well, when he's designing, he has the advantage that he builds. He knows how products go together. He knows how things fit. So when he's designing, he will also have the forethought if he knows how that product's got to go together and how it works. So that's why the law gives him a higher standard of fitness for purpose, because the law views the contractor of having not only the design knowledge, but the buildability knowledge as well.
Just the last one. I'm not in NEC. There's been not sure CDM. How does CDM or changes to CDM regulations actually apply to any liabilities? I'm assuming.
Well, that's to do with health and safety.
Health
it's
and
nothing
safety.
to do. Yeah.
Okay.
Any more questions? Actually, we are kind of running out of time. Thank you so much, Matthew. I would like to remind everyone that next week, Matthew is going to be here again talking to us about terminating a construction contract. You can't miss. Invite your colleagues. Let's make this room full for the next week. I would like to applaud you because it was a very, very interesting presentation. Thank you so much. Very important. And I hope to see you all next week.